Hi everyone, we are here for the second webinar of the European Union Law and Sustainable Development webinar series. We are very lucky and pleased to have with us Dr. Laurence Ankersmit from ClientEarth and from the University of Chance Brussels School of International Studies. I'll just give the floor to Professor Riccardo Pavoni of the University of Siena and academic coordinator of the EU Law and Sustainable Development. I remind you that if you're watching this live on YouTube, you have a chat on the right of your screen where you can write your questions, and we will ask the question at the end of Dr. Ankersmit's presentation. Professor Pavoni, to you.
Yeah, this is just a couple of words to say that we are very, very grateful to Laurence Ankersmit for accepting our invitation to be a speaker for our webinar series for our Jamone module. And okay, the reason why we thought about Laurence, I think we must be disclosed, because Laurence has just published a book on which is entitled Green and Fair Trade in and with the EU with Cambridge University Press. We had a look at the book before, now we have read it, and it's really, we think that it's an impressive piece of work which is dealing with this problem, with this never-ending problem of the intersection of trade and environmental protection. Of course, this is a debate which dates back to many decades, some decades ago, but it's still very much a lively debate. There are continuous developments. So we really thought that it was great to have him with us for this webinar series. Just a couple of words on his biography, which is a short biography because he's very young. Laurence Ankersmit holds a Ph.D. from the Vrije Universiteit in Amsterdam. He's currently a lawyer for ClientEarth, which is as well known as one of the most important environmental law organization, and he also holds a teaching position with the Brussels School of International Studies at the University of Kent. I would like to just recall that also one important thing, that Laurence is the editor of the European Law blog, which is certainly one of the most well-known blogs dealing with European law. So we're really looking forward to his talk, and we can give the floor. The floor is yours, actually, so you may start.
Hello, everyone. Thank you very much for that introduction and for those kind words. It's a pleasure for me to address you today on Europe Day. So happy Europe Day, everyone, 9th of May. I will now just start my PowerPoint, so I think you will no longer see me when I press a certain button, and then we can start. So the PowerPoint is just to also facilitate the discussion. So, as was briefly mentioned, what I'll be talking about today is the current state of the trade and environment debate in EU law. And what I'll be doing is I'll be talking about this long-standing debate about the intersection between trade and the environment from an EU law perspective, and also from a perspective of current developments in EU law in this respect. So that will also be dealing quite a lot with the current trade policy of the EU and of the Commission in relation to third countries and the intersection with the environment. So just to before I start with that, I wanted to briefly just give a little bit of background about where the controversy comes from in this discussion about the intersection between trade and the environment. Basically, in the 90s, basically two international economic regimes had to deal with this intersection between trade and the environment. and that's within the context of the WTO and also the GATT, the General Agreement on Trade on Tariffs and Trade, and international investment law. And probably like the most quintessential case about this debate was that reflects this debate was a case that was brought by Mexico against the United States over an animal welfare measure that the United States had introduced. And this was basically a ban on imports of tuna that was caught in a certain way outside US territory. So basically what happened was that Mexican fishermen were using a certain technique of fishing which killed dolphins when they were fishing for tuna. Basically they used pole sign fishing, and they caught the tuna by also drowning dolphins. And this created quite a lot of controversy in the United States, and that resulted in an import ban in the United States. And Mexico challenged that measure before a GATT panel, a trade panel basically. And that panel found that the measure of the United States was extraterritorial and therefore not permissible under the General Agreement on Tariffs and Trade. And that caused a huge controversy and backlash against the international trade regime, because it was seen that it was seen as an infringement on the capacity of governments to regulate in the name of the environment, in the name of animal welfare, and therefore caused quite some controversy. And there have been a few cases since, also before the WTO, that did deal with this particular type of measure, where you're not regulating the product as such, but you're regulating the production method of that product. And therefore you are, let's say, dealing with something that is happening in another jurisdiction. You're regulating a product on the basis of the production outside your own country. So this is referred to as the debate on PPMs. And this particular type of measure has created quite some debate within the WTO law scholarship. Now, in a different regime that's also quite focused on, let's say, economic rights, is we saw a similar discussion surrounding investor-state dispute settlement. So a lot of governments have concluded, also especially since the 90s, investment agreements, and those investment agreements have their own tribunals as well. And those investment tribunals, ISDS, allow investors to directly challenge also environmental measures for the reasons that it creates damage to their investment. So there are a whole load of these cases, and this has also caused quite some controversy. Probably the most well-known one is one that's currently pending, and that's Vattenfall's suit brought against the German government for the German government's decision to phase out nuclear power. Now, this debate all happened within, let's say, a bit of a confined context, where the purpose of this international law was very much dedicated towards trade liberalization and investment protection. Within the EU, the relationship with trade and environment can be said to be a little bit different. And of course, the EU treaties are originally a trade agreement as well, but the goals of the EU treaties are very different and much more ambitious. So whereas like the goal of the WTO agreements is much more to liberalize trade, the EU sees trade as a means to achieve other aims. And of course, the most notable goal is, of course, to create an ever closer union. So environment is much more embedded in the European regulatory context. And of course, also the EU has the possibility of regulating its market itself. It's not all about trade liberalization, it's also about trade regulation. Now, what we see, though, is that in the current context, the Commission, in its approach towards trade, is still, is focusing still very much on trade liberalization and not so much on trade regulation. So although there is quite a lot of debate about environmental standards in Europe, the fact that, and this is probably caused by the fact that the EU is actually, in its trade policy, focusing so much on trade liberalization. That creates some concerns, at least with NGOs, about what that means for environmental standards, what that means for goods that are being imported into the EU that might not meet very high environmental standards. And that's also why we see this controversy around TTIP and CETA. So what I'm going to basically do in this talk, I'm going to talk about two different aspects of the EU's contribution to this debate on the intersection between trade and environment. I'm going to look firstly at how the EU externally approaches this this intersection, and I'm going to be mainly speaking about like the current generation of trade agreements and how they interact in this debate between trade and environment. And then secondly, I'm going to talk a little bit more about the internal situation in the EU, because the EU can also, as I said, regulate its markets and therefore also regulate incoming trade, products that are traded into the EU. And also the member states have the ability to regulate their part of the internal market, and there are also private initiatives that are disciplined by EU law as well. So I'm also going to be speaking a little bit about that. But it's mainly the intention of this overview is to give you a good overview of the current state of this debate and the intersection in trade and environment. So first, I'll start with trade agreements, the EU's trade agreements. So that's really the flagship of the current trade policy of the EU, is to negotiate bilateral trade agreements. These are very comprehensive in scope, and one of the things that the Commission and the EU institutions are keen on doing in negotiating these trade agreements is having a sustainable development chapter in the free trade agreement. So although the agreement overall has as its objective to liberalize trade between the EU and a third country, you see that there is a dedicated chapter to sustainable development. Now, these chapters have come under considerable criticism by NGOs. The main reason for that is that these chapters are not seen as having much added value, not really delivering in terms of adding to environmental protection between the two countries, and basically is seen a bit as greenwashing, so to speak. Now, what the EU does with these chapters, so in a way, it's good, of course, that there is such a thing as a sustainable development chapter, is that the EU opts for a cooperative model, as it itself refers to. If you compare this to the United States also has dedicated chapters to the environment, but there the focus is much more on laying down concrete obligations and making them enforceable through sanctions or penalties. Now, the EU is very much focused on having like basically a broad approach that facilitates discussion and cooperation between the EU and the other country, and at least from the chapter itself, excludes the possibility of introducing sanctions. So there's a dispute settlement provision in that chapter that only relates to that chapter, and that dispute settlement provision does not explicitly allow for sanctions. It's basically consultations, and then you can have in a second phase a report by a panel of experts. Now, there have been some interesting developments in the case law of the European Court of Justice in relation to these trade and sustainable development chapters. And that is basically Opinion 215, which is a recent case on the extent of the EU's competences in the field of trade. It was requested by the Commission, this opinion, to clarify basically the division of powers between the EU and the member states. Now, there are two very interesting findings in that opinion that I just want to mention here. Is firstly that the European Court of Justice considers these sustainable development chapters to be an integral part of the common commercial policy. So basically that means that environmental aspects of trade can be considered to be part of the EU's exclusive competence to regulate and liberalize trade. So that means that member states are no longer necessary to conclude an international agreement that contains these commitments on environment in these trade and sustainable development chapters. So in a way that really empowers the EU to regulate also environmental aspects in its trade agreements. The second very interesting thing about Opinion 215 is paragraph 161 of that judgment, where the European Court of Justice takes quite an interesting approach towards sanctions. So the Commission has always and is still saying publicly that its approach is that sanctions are not possible under the trade and sustainable development chapters. But according to the European Court of Justice, a breach of one of the provisions in these chapters allows the other party, on the basis of customary international law and on the basis of the Vienna Convention, to suspend partially or even terminate the agreement. So according to the European Court of Justice, sanctions are possible under the TSD chapter. Of course, this would require a Commission proposal and a Council decision to suspend the agreement. So I don't see it happen very soon when it comes to the EU side of things. But it is interesting to note that the European Court of Justice went out of its way, basically, to take such a different approach than the Commission. Now, a second aspect of the current trade and environment debate in the EU is the fact that the EU is negotiating an investment chapter in its trade agreements. And this is a new thing that basically results from the Lisbon Treaty, where the competence to regulate foreign direct investment has been transferred from the member states to the EU under the Article 207 of the TFEU. So that basically meant that the EU brought on board a hugely controversial area of international law, international investment law. And the controversy is mainly the result of the fact that these investment agreements traditionally, and there are over 3,000 of these agreements, contain investor-state dispute settlement. And I already mentioned that before. It's basically used by foreign investors to challenge any measure that affects their investment. And that can include environmental measures. And that's why so many civil society organizations are opposed to this system, because it basically allows these foreign investors to go to an international tribunal directly and claim damages. And those tribunals are considered to be not, well, at least from a civil society perspective, sufficiently independent to administer these type of very, let's say, big picture public interest cases. Another aspect that's interesting when it comes to ISDS is that in the past has shown that really that system tries to preserve the status quo. Like the intention of an investment agreement is really to provide for a stable business environment for foreign investors. And that might make it more difficult for governments sometimes to take measures that would depart from previous legislation, because that might result in a claim that is either winnable or not. And that's particularly quite important for let's say environmental groups, because this might hamper the energy transition. Also because we've actually also seen some really interesting cases brought by foreign investors that challenge renewable subsidy measures. So we see that like this instrument is kind of used to mess around with government policy in the field of the energy transition. Now, because of the whole controversy around TTIP, and mainly the TTIP is the agreement with the United States, and CETA, which is the agreement with Canada, the Commission has sought to address some of the flaws of ISDS, or the perceived flaws at least, by introducing a new form of investor-state dispute settlement that's referred to as the investment court system. And that's basically a system where the appointment of the arbitrators, so let's say the judges, and they're not really judges, but the arbitrators, the appointment goes through the parties themselves and is no longer administered by the investor previously was able to pick its own arbitrators. And that's what the EU is trying to cut out, is trying to make it more of a government-led system. And as a result of that investment court system, the Commission is also further trying to improve that by introducing an initiative, and it has just gotten the mandate from the Council to negotiate a convention establishing a multilateral investment court, which is really going to, let's say, institutionalize investor-state dispute settlement and provide for, let's say, real judges that would administer these disputes between investors and states. The big question here, though, is whether the EU can actually negotiate such dispute settlement mechanisms in the first place. And this has been at the forefront of the discussions about ISDS in the EU context, whether the EU could do such a thing in the first place. And there are two very interesting cases that one is pending, the other has been decided on this issue. It's the Achmea case, which has been recently decided this March, and Opinion 117, which was a request made by Belgium to the European Court of Justice to get legal clarity over this situation. And if you're not completely familiar with this issue, or why is the EU not in the possibility to negotiate such an agreement containing such dispute settlement mechanism, it is basically because the EU treaties protect, or that's how the European Court of Justice interprets the EU treaties, protect and preserve the powers of the courts of the member states, as well as that of the European Court of Justice in a very significant way. Basically, you cannot negotiate an international agreement that adversely affects the powers of the European Court of Justice and that of the courts of the member states. The courts of the member states are really are central and a very important components to how EU law is administered. And basically what the ECJ does not want is that system is adversely affected by international forms of dispute settlement. So I made this little figure that maybe explain it a little bit more, just like in a very abstract way, so to speak. Basically, if a foreign investor has a dispute with a government and that relates to a field that is covered by EU law, you have to go to a member state court, because that member state court is then in the position to refer a question, if there's a question of EU law, to the European Court of Justice. And this basically ensures that the EU's judicial system and legal system can properly function. It means that whether you're in Italy or whether you're in the Netherlands or whether you're in Poland, EU law means the same thing everywhere. And that's very, very important for the European Court of Justice. And what happens with ISDS is basically that a Belgian company, for instance, that is owned by a Canadian investor can sideline, it no longer needs to go to a member state court, but is in the position to go to ISDS. So this is a very contentious issue that is currently pending before the European Court of Justice. And that's Opinion 117. So that's definitely a case to watch out for. Now, a third controversial aspect that I'll only very briefly touch upon is regulatory cooperation. It's a chapter that's included in most current generation FTAs, including the one with Canada, the CETA. And basically, this is very controversial because rules and regulations of the EU and of Canada get discussed in a trade context. So it's a bit of a nuanced discussion. But of course, regulatory cooperation with Canada might be very beneficial for the environment. But that would be more the case if that would be discussed in, let's say, the context of an international environmental agreement. And here, the focus is on trade facilitation. And that's why a lot of civil society organizations have so much doubts over this particular chapter in these trade agreements. And if I can just briefly refer to one article that is written by Maria Bartel, it's publicly available online in a journal called Europe and the World. It's a very good article that explains a little bit more why regulatory cooperation is quite controversial from the perspective of rulemaking in the field of the environment. There's basically a threat that when it comes to the implementation of chemicals legislation, things might be watered down a bit because regulatory cooperation allows the Canadian government, for instance, early access to the implementation of EU rulemaking in that field. Now, a second aspect of, let's say, the external area of the EU trade policy that I just wanted to briefly highlight is the anti-dumping regulation. The anti-dumping regulation has been revised last year, and it's really interesting because it's the first time that I've seen such a thing in like a trade instrument, is a reference to environmental standards. Basically, what the and it's still a very cautious approach, but the anti-dumping regulation basically means that the EU can impose duties on a product that it considers to be dumped on its market. So let's say Chinese steel that might get dumped on the EU's internal market. Then there's this regulation that allows the EU to impose these anti-dumping duties. And what's very interesting is that in determining that anti-dumping duty, you need to construct a normal value, and usually you do that by looking at the price in the exporting country. But if that's not possible because of significant distortions, you are able to pick a comparator country. And what the anti-dumping regulation does is it instructs the EU institutions to basically pick a comparator country which has high environmental and labor standards. So that's a very interesting, like I think an innovative element to the anti-dumping regulation, which basically brings the environment in the picture when it comes to anti-dumping rules. Now, moving on to the second big part of what I wanted to speak about, trade regulation. And this is more like, let's say, the internal component of the EU's trade relations with third countries, which relate to like this bigger trade and environment debate. And basically, there are three levels in which trade can be regulated to protect the environment. You can do it at EU level, at member state level, and you can do it at private level. So I listed here on this slide the PPMs, as like those measures I mentioned in the beginning, where the EU basically has regulated the internal market to protect, among other things, the environment elsewhere. So there's a whole list of PPMs. So you see that the EU is actually quite itself quite active in making these rules, although there haven't been like a lot of new rules. The only one that is of recent times is the conflict minerals regulation that was adopted, I think it was actually late 2016, but maybe it was 2017, the number says 2017. So you see that the EU actually itself, compared to like, I mean, this is not possible for the WTO, for instance, takes these types of measures that basically restrict access to the EU's internal market on the basis of the production process elsewhere. And there, I mean, with these PPMs, the EU addresses different topics. So it's not only environmental protection, but a lot of this is animal welfare regulation, for instance, the leg hold trap regulation, or the egg marking rules, or the seal products regulations, very, very geared towards animal welfare protection. But you also see more environmental goals, or let's say social goals through these PPMs. Now, in terms of like current developments, I think what is interesting to point out is the quite a lot of controversy around palm oil at the moment. Of course, many of you might know this, but there is a huge concern over the impact of palm oil cultivation, in particular in Malaysia and Indonesia, on climate change, deforestation, human rights issues. There are all kinds of issues related to the import of palm oil from these countries into the EU. And the European Parliament has adopted a resolution in 2016 that has really listed a whole bunch of PPM measures that they want to introduce, or that they have asked the Commission to propose. But nothing has come so much of that from the Commission side. So I think the Commission is still very much being very cautious in considering its options, but we haven't seen any type of proposal so far. So this resolution was passed by an overwhelming majority in the European Parliament. So there's a very clear demand from citizens' representatives in the EU, but we see that the Commission is still very hesitant, and the Commission does, of course, have the right of initiative to actually regulate palm oil, the import of palm oil into the EU, on the basis of environmental considerations. Now, if we look at the second level, member state regulatory activities, I think it's important to point out, and a lot of people tend to forget that, is that the regulation of the EU's internal market is a shared competence. It's a shared competence between the EU and the member states. So the member states are fully capacitated to regulate the internal market for what concerns their territory. Of course, they are disciplined under the EU treaties by the free movement of goods rules. And basically, you have two types of disciplines. You have the, let's say, the more general rules under the Article 34, which prohibits quantitative restrictions on imports and measures of equivalent effect. So basically, that prohibits trade restrictions between member states, unless justifiable under either Article 36 or the general like case law-based justifications. And a second regime is taxation. So we have Article 30 on customs duties, internal customs duties, but we also have Article 110 that prohibits discriminatory taxation. Now, what you see with PPMs is that the European Court of Justice interprets these provisions in a way that allow for PPMs. The PPMs are not treated in any way differently from other market regulation tools. So that's quite different from, let's say, the discussion in the WTO context. And you see when it comes to taxation, for instance, that the ECJ even explicitly states that member states are permitted to differentiate product taxation on the basis of the production methods used. I've listed three of these cases. Bobi concerns, for instance, small beer production. Outokumpu is green electricity. Another very important aspect of, let's say, a way of how member states can contribute to like a more green form of trade is by using their public procurement policies, by buying products that take into account how a product was made in countries outside of that member state. And what is very interesting is that in the recent directive adopted, well, it was already 2013, but the reformed public procurement directive is very explicit in permitting public authorities to contract goods, or to buy goods basically on the basis of how they have been made, to take into account environmental production criteria, to take into account social production criteria. And that is really something that is very positive, because well, at least from my perspective, because it allows public authorities, so little, like for instance, municipalities, a small municipality would be in the position to use its procurement policy to actually to buy goods that do not have a bad impact on the environment. There's one, let's say, downside to the public procurement directive, in my opinion, and this is a bit of a consequence of ECJ case law, is that this procuring needs to be linked to the subject matter of the contract, and that is a bit of a, let's say, a little bit of a technical term. But what that what the court means with that is that you can basically only say, okay, I want green electricity, and you can buy only green electricity, but you may not require the electricity company to only produce green electricity in order to supply you. So you can make sure that the product you are procuring is green, but you cannot impose, let's say, or require a more corporate social responsibility policy from the company that is providing you the goods. So in other words, the Public Procurement Directive goes a little bit against current Commission policy and corporate social responsibility, which really is geared towards going beyond current legal obligations and really requiring undertakings to do in a general way good when it comes to environmental protection and social protection. And we see the Public Procurement Directive is complicating things in that regard, although I think that still it's quite positive that PPMs are explicitly permitted under the Public Procurement Directive. So the last level that I briefly wanted to touch upon, where we see the regulation of trade for environmental protection purposes, is private initiatives. So companies, of course, they can have a corporate social responsibility. They can try to advertise their products as being green and therefore get into to have like an advantage on the market. But sometimes, for various reasons, this might not be a viable approach. Maybe consumers do not care about how a product is made, or they might not know about it, or there might be all kinds of issues that make it difficult for companies to actively compete on environmental production characteristics for their products. It's like one thing you cannot, let's say, you cannot taste slavery, for instance, in chocolate. Like we cannot. That's not possible. So in those situations, companies might be interested in agreeing with their competitors to say, like, okay, we're going to try and ensure that there will be no chocolate that is produced by slavery in our supermarkets, for instance, and let's all sit together and agree on that. Now, there are a couple of these examples actually of companies doing that, and they're I don't know why, but they all come from the Netherlands. So there was an initiative by well, quite a big group of civil society actors, but also by the largest producers of electricity in the Netherlands to close their most polluting coal-fired power plants. So it was a reduction of production. Basically, these energy companies said, okay, for climate change purposes, we are going to close our coal-fired power plants. Another example is also Dutch supermarkets trying to ban the selling of factory farm chicken by improving basically animal welfare conditions of the chicken sold in their stores. Now, this was blocked by the Dutch Competition Authority. And they blocked this because, according to the Dutch Competition Authority, these types of initiatives are a violation of the EU competition rules, so Article 101 of the TFEU. And that's a very interesting discussion. Why is that a restriction of competition under Article 101? Well, basically, if you look at the case law of the European Court of Justice, such collusion between competing undertakings might have an effect, a negative effect, on one of the parameters of competition. So it might have an effect on the price, it might have an effect on the output of products, on the diversity of products, it might exclude a rival. And for that reason, if it has an appreciable effect on competition, then it might be prohibited under Article 101 TFEU. Now, in my opinion, the Dutch Competition Authority didn't sufficiently look at the possibilities to actually justify these types of initiatives under the EU competition rules. And I think there are two ways of justifying such restrictions. The one is let's say a more economic approach. That's the one that's explicitly provided for in the treaties. Article 101, paragraph 3, TFEU allows for a derogation of Article 101, paragraph 1. Those are the competition prohibition. If there's economic progress can basically be achieved by such a restriction of competition. And you can interpret those as four conditions that you need to meet. You can interpret them restrictively, or you can interpret them quite broadly, and that's basically a question of like competition policy. And in my opinion, the European Commission and the Dutch NCA are being way too restrictive in how they look at Article 101, paragraph 3. A second option is to basically apply the so-called rule of reason to such cases. So to say, like, there might be a restriction, but on the basis of the rule of reason, there might be a public interest justification that is unrelated to, let's say, an economic justification that might justify such a restriction of competition. And there are a few cases that have introduced this type of justification. And I think one of the most interesting ones is the Mecca Medina case. Is basically a swimmer that was banned from international competition because that swimmer had taken doping. And there was a private rule by sports association that did not allow swimmers to compete if they had taken doping. So that's basically a private rule. It's that was applied in this context. It was a restriction of competition, but it was justifiable because there was a demonstrable. Basically, it was an inherent restriction to the proper administration of sports. So yeah, I think like those types of cases do provide for some more scope, and it's really about the competition authorities, in my view, becoming a bit more open to those kind of types of things. Now, I'll just have a few concluding remarks, because I think I'm definitely approaching 45 minutes. So I want to have some time for discussion as well. Basically, when it comes to the current trade and environment debate in EU law, you see that the Lisbon Treaty, or since the Lisbon Treaty, we've been faced with new challenges, and that those new challenges mainly relate to the enlargement of external competences of the EU, and also the Commission's approach to external trade policy. So now that we have the negotiation of investment agreements that contain investor-state dispute settlement, or the ICS as it is called currently, a very broad approach to liberalization of trade that might also affect environmental rulemaking. But on the other hand, I think, like, if we just look at the internal component at the EU, I think there's a wide scope of possibilities to regulate regulate trade in the interest of the environment. Member states are permitted under EU law to do a range of things that could address environmental protection elsewhere. The EU itself can also take these measures, and has taken a lot of these types of measures. And I also think that even when it comes to private measures, there are also possibilities there. So I'll leave it at that. I'll just go back to the Hangout. And I give the floor back to the hosts. Thank you very much.
Thank you so much, Lawrence. This was extremely valuable for all viewers and from us as well. It's great that it also serves as a nice way to frame the little discussion that we're going to have, hopefully building on some of these aspects that you touched upon, and potentially, of course, if there's an interest, touching also on more policy sort of in hot topics in EU trade policy, in case our viewers are interested. Feel free to use the chat to ask questions to our guest, but I would like to maybe give the floor to Professor Riccardo Pavoni for a follow-up question, so that we can start the debate, maybe. If you have any, otherwise I can go forward.
Oh, yes. No, I would like to thank Lawrence for this extremely rich and stimulating talk. I mean, he addressed so many topics and questions, which is really difficult to isolate the most important questions here. Perhaps I just have a couple of remarks, which are also, in a way, questions to him. With respect to the first part of his speech, he's talking about this external dimension of the problem we are addressing, the trade and environment interface. I always had doubts I've always had doubts about this, let's say, insistence of the European Court of Justice on the exclusive competence of the EU in the trade area, when that means that also the environmental components of the trade policy is also the subject of exclusive competence. And this has been, of course, most recently reaffirmed by the court in this opinion 215, which Lawrence described. I mean, at the end of the day, as he correctly underlined, to say that these trade and sustainable development chapters are an integral part of the common commercial policy means that the EU has exclusive competence in that area. I don't see what he really thinks about this. Do you think that this is really good in all respects? Because I've always thought that here, let's say, concurrent competence of the EU and its member states may be salutary from the point of view of environmental protection, while I never had the impression that the insistence on the exclusive competence of the EU is necessarily beneficial to environmental protection. I'll just stop here for the moment.
Thank you, Professor, for an excellent question. I think I didn't really address it, but I completely agree with you. I think there are a couple of very interesting dynamics that go behind this decision to give the competence to conclude these TSD chapters to the EU that are, I think, also, like what you're saying, that could be detrimental to environmental protection. First, perhaps it's interesting to refer to this article I once read by Professor Jans, Stop the Integration Principle. And he basically says that, like, because of these integration articles that the ECJ also refers to here, it basically results in a transfer of competences to the EU in areas where you would think that should actually be at least shared competence between the member states. So it's mainly, it's not really something that actually promotes environmental protection. It just enables the EU to do certain things in those areas. And what this means, of course, is that to have these TSD chapters to make that like EU competence is basically, it's DG Trade now that is ensured of the competence to at EU level alone to regulate these chapters. And I think the only concern that DG Trade really has, in my opinion, and this is my experience talking discussing these issues many times with Commission officials from DG Trade, is that what they really care about is the fact that it's now EU competence. They don't really care about actually protecting the environment. So for instance, what they're quite keen on doing is to not overly complicate TSD chapters, which may result in a transfer of competence back to the member states. So it's all about power in a way, which is not something that, it's not about environmental protection or trade, it's about power. And that's a little bit disappointing, because I think that these TSD chapters should be aimed at really trying to protect the environment. And what we see is that the Commission is quite happy with the current approach because it ensures that it's EU exclusive competence. And they fear that if it would be enlarged, so if there would be all kinds of extra commitments that actually go beyond, like, let's say, trade aspects of environment, then it might be member state competence again. I hope that's a helpful answer. So my short answer is that this is actually a little bit of a bad thing. Yeah. What happened?
Perfect.
Okay, maybe I'll add one question as we wait for our viewers to write their own. I see that they might be a bit shy today, actually. But anyway, I wanted to actually build on what you just said, because this relates to an interesting point that you make towards the end of your book, where you highlight how many of the social and environmental safeguards that have been advanced recently through EU legislation have been then developed by directorates other than DG Trade, particularly, of course, DG Environment. And in the book, you talk especially of process-based measures, but I think the argument goes even beyond that. So in this phase and in the context of the steps taken by the EU Commission to implement the 2030 agenda, do you see opportunities for increased engagement beyond the current Trade for All strategy, which remains basically centered around TSD chapters in the EU trade agreements? Do you see an increased engagement on the adoption of and on the promotion of other measures, including process-based measures, but beyond that as well?
Yeah, I mean it's a very pertinent question, and I think to be honest, I'm just a bit skeptical about anything coming from DG Trade. I think the focus from like the Commissioner Malmström, and also I mean this Parliament that's backing this Commission, is very much geared towards trade liberalization and trying to forgive me using these words, but pretend to do something in the environment to appease certain sections of the population in Europe, but we can't expect too much from DG Trade, in my view. I mean, the palm oil issue is, I think, a good example of that, where we still haven't seen anything coming from the Commission. So I think we should, I think like if anything is to be expected from the Commission, it's probably more likely to come from other DGs that are less concerned with the impact it might have on trade relations with third countries, and more concerned with protecting the environment, so in particular DG Environment. But going beyond that, I think, and this is a thing that is, in my view, surprisingly not used sufficiently, is member state regulation. Member states can regulate their part of the market. They are entitled to do this, and this has triggered EU regulation in the past. If we look at the seal product regulation, for instance. So it is possible, for instance, for member states to regulate the sale of palm oil on their markets. It's of course something that's considered that needs to be done at EU level or something. But if that doesn't happen, member states are in the position to do this. So I think maybe the hope should come more from like the member states rather than the Commission.
Thanks for this. Actually, if I may, just very briefly building up on this, and then maybe going back to Professor Pavone in case he wants to follow up as well. What is your opinion? Again, building on these concerns, what is your opinion on the recent consultation launched in 2017, which sought to identify how to better implement and enforce TSD chapters in EU trade agreements? I recently happened to read the non-paper of the Commission Services, which highlighted how there were several key steps that were identified, and three areas in particular where substantial strengthening and improvements were proposed and recommended. And one was climate change, the other one was the scope for civil society engagement, and the third one is the resources to support implementation. Do you think that if this is the way where we're going, as you were, saying in terms of what the Commission is also pushing for, do you think that this is sort of incremental process of improvement is enough to at least make TSD chapters more effective?
So I mean, there were two non-papers or two papers by the Commission on the TSD chapters. And my impression is very much that the Commission is quite happy with its current approach, but that it just wants to become a bit more assertive to show that its approach is actually working. I think that's how we should read those two papers. The Commission is completely opposed to the idea of sanctions. And this is, I mean, this is a kind of a recurring issue, but civil society and trade unions, and basically also actually the S&D group in the European Parliament, they really want the TSD chapter to be at the same level as the other chapters in FTAs. They want to make sure that that those chapters are valued as such, and that there is the possibility of saying, like, okay, if you do not comply with the agreement we've made here on these environmental standards, then there should be consequences. Now, when it comes to sanctions, I think that is a very valuable and legitimate argument, but as you say, I think the most important thing is to get the substance right, is to actually ensure that these commitments in the TSD chapter are meaningful, so that they concretely and significantly contribute to protecting the environment. And there are a lot of ways of doing that, and I really hope that the Commission is going to be open to introducing that. I am a little bit skeptical about whether they're actually going to do that. I actually don't think that so much will happen, but maybe the second paper opens the door a little bit towards that possibility. When you talk about climate change, of course, where that comes from is the fact that in the context of the CETA debate in France, basically the Macron government said, okay, Paris must be first and central to all these new FTAs. And we are not signing off on any agreement that does not have like a very clear reference to the Paris Agreement. That's all fine and good. That's now like quite central to the Commission's approach as well. But it's all about, the devil is in the details, so to speak. So it's all about what kind of specific commitments are you going to put in that TSD chapter that is actually going to contribute to the fight against climate change. For instance, are you going to have elaborate provisions on the transfer of climate-friendly technology to developing countries in an FTA? That's something that's quite contentious, because it goes against the interests of where DG Trade looks after generally, and that's the business community here in Europe.
Yeah, thank you actually for the very exhaustive answer. Professor Pavoni, any follow-up question here? I see that we don't yet have comments on the chat, so I'll just assume that maybe if you have any question, because we have just a few minutes left, so in case maybe one closing point.
Yeah, because we don't want to steal more time from Lawrence, many commitments. Perhaps just a short feedback on the investment part of his talk, because of course there's a lot of talks about investment law. I think it's the field of law more explored in these times. The doctrinal contributions are never ending, etc., etc. So just a couple of, let's say, very short remarks or questions, which are more for the broader audience than for lawyers, because I haven't followed exactly all the recent developments in this area, but I studied a lot about this in the past. You are talking about this movement now towards the establishing of an investment court system, and especially towards the establishment of a multilateral investment court, which I think that in itself may be a welcome development. But let's say, the layman would ask you, why isn't it possible for host states to sue investors who harm the environment, for example? Because we know that this system is made for investors. Investors may sue states, but states cannot sue an investor which, for example, causes environmental destruction. I know it's an old story, but perhaps you have a
it's very topical, actually. It's actually one of the things that is, I think, also central to the establishment of of that multilateral investment court is to whom is that court going to open its doors? Because I would actually extend the number of applicants from 2 to 3, because I think also affected local communities should have the possibility for judicial relief against transnational corporations if something bad has been done by that corporation. And I mean, I think if you're going to put this at the international level, if you're going to transfer such disputes, the resolution of such disputes from between investors and states and local communities, if you're going to transfer that for one group to the international level, I think you need to make the system more balanced. And you should allow for counterclaims or even independent claims by states, but also you should also look at affected local communities as well. I think if you're going to make it international, then it should be at least a balanced system. And this is something that is, I think, is up for a discussion. I don't think that the European Commission is in any way in favor of that. Like, they really want to preserve the one-way direction. They want to improve the selection of the judges, and that's all quite positive. But they do not want to approach the premise, the basic premise of the system that allows investors to bring cases and not other affected groups and states. So I think that's unfortunate, but we'll have to see how it pans out. Maybe the European Parliament will push back a bit on that issue. Maybe it has to grow. I'm sure that there are quite a lot of developing countries that are very critical of ISDS. That might also be in favor of such a system. And I'm just maybe the last comment on this particular point is that the model BIT by the Southern African Development Community and the model BIT by India, so bilateral investment treaty, both contain the possibility of claims by states against the investor for violations of environmental and social law.
Thank you so much for this. I didn't know about that. So Dario, you want to wrap up?
Yes, I think we've run slightly over time, and so I take this as a chance to thank again Lawrence and all the viewers who watched this live. You will have, of course, the opportunity of watching this again, or you might watch this for the first time recorded on YouTube. We really take the chance to give you the to ask you to save the date for the next webinar, which is going to happen around the second week of June. In the next few days, we will set the official date, and we'll start communicating that on our channels. Thanks again, Lawrence. It was really a pleasure having you, and extremely interesting and informed conversation for all of the viewers to watch.
Thank you very much. Thank you.
Goodbye. Bye-bye.
You too. Bye.